Good afternoon. Go ahead and call the meeting to order. We are here for City of Titusville, Florida, code enforcement hearings. These are public hearings. These are quasi-judicial public hearings, and I am the special magistrate who has been appointed to hear these cases. Formal rules of evidence do not apply, but fundamental due process shall be observed. Everyone who has a case today will have an opportunity to present testimony. You may present evidence or witnesses to testify on your behalf. There is no public comment portion. You must be a respondent or be called as a witness in order to speak on a specific case. Everything today is being recorded and all testimony will be under oath. When you are sworn in, please provide your current mailing address so any orders get to the correct address. The city will present its case first and information will be displayed up on the screens. The city's PowerPoint presentation will be entered into evidence unless objections are made. You are entitled to present your own evidence to support your case. After the evidence is all presented, I will make a ruling, and that ruling will be reduced to writing, and it will be provided to you by mail. And we will go ahead and swear in all of the witnesses, please. And if you are intending to testify, please go ahead and get sworn in as well. If you're going to testify about your case, go ahead and stand up and get sworn in. Do you swear or affirm that the testimony you provide shall be the truth, the whole truth, and nothing but the truth?
Good afternoon, ma'am. If we would, hearing 20-47, staff would like to continue that 30 days as we are making some forward progress towards compliance, and the inspectors asked for 30 days.
Continue to the
Next hearing,
or till the next,
January.
Next possible hearing.
Yes, ma'am.
I will continue to the next possible hearing date.
And case number 20-48, that is in compliance as of Friday.
Do you want to just pull that from the agenda, or do you want an order of compliance?
We would just pull it from the agenda.
Okay.
Thank you, ma'am.
Thank you. So is your first case 20-46 then?
Yes, ma'am.
Okay, 20-46.
Good afternoon, Your Honor.
Good afternoon.
We'll see if I can get this thing to work. Okay, what am I doing wrong, Glenn?
They're going to physically advance it, so ask for the next slide.
Okay.
Next slide. No, we're not on that there.
Too far.
Back to the other side now. Get where it is. Yeah, may have to back up to the original. Okay, there you go. You should work.
Theoretically. Okay. Okay, we'll try again. Okay. First off, let me say that this case actually belongs to Officer Ken Hutchings. He is absent. I am presenting his cases for him today.
Okay.
Okay. Case summary is for property reference at 504 Short Street, owned by an Antonio and Patty Malatestis. The initial inspection was done August the 18th, 2020. Notice of violation posted on site. Notice to the owner was mailed 8/19, certified and delivered on September 10th, 2020, but no return receipt back as of yet. The notice of hearing on the October 21st, 2020 was posted at City Hall on the property where the violation exists. Certified mail was mailed on 10/7/2020. According to tracking, the notice is still in transit. The compliance date originally given was September the 2nd, 2020. There's been no contact with the owner. Follow-up inspection on November the 2nd, 2020. Still no progress. The reinspection, at the reinspection date, the owner has not removed the vehicle or cut down the overgrowth. It was still like that today at around 11 a.m. this morning. Okay. The city code defines section 1373 inoperable vehicles. Time limit for disposition exception. No person in charge or in control of any property within the city, whether an owner, tenant, occupant, lessee, or otherwise, shall allow any inoperative vehicle to remain on such property longer than 72 hours. No person shall leave any vehicle on any property within the city for a longer time than 72 hours unless the vehicle has a current tag and registration. Only one inoperative vehicle at a time shall be allowed to remain on such property during the aforementioned 72-hour period. There we go. City code defined, again, is the weeds, section 6-109, International Property Maintenance Code, section 302.4, weeds. Premises and exterior property shall be maintained free from weeds or plant growth in excess of 12 inches. Noxious weeds shall be prohibited. Weeds shall be defined as all grasses, annual plants, and vegetation other than trees or shrubs provided. However, this term shall not include cultivated flowers and gardens. And again, I'm killing it. There you go. Now this is a photo of the original notice of violation posted on the property. You can see the overgrowth right back behind the posted notice. You can see the vehicle in question, vehicle in violation. It's a pickup truck. There we go. All right, this photo is the hearing notice posted by Officer Hutchings on September the 15th, 2020. It won't change. There we go. Okay, the recommendation based on the testimony and evidence presented in hearing case 20-46 to determine that the respondents Antonios and Patty Malatestis, hope I'm pronouncing that right, the owners of record of property located at 504 Short Street, located in Titusville, Florida, as determined by the property appraiser's records, in possession or control of property and in violation of Titusville Code of Ordinances, section 13-73 and 6-109, International Property Maintenance Code 302.4 as defined. It works when it wants to. Next slide, please. Okay. It is further recommended that the magistrate order the respondents to correct the violation on or before January 11th, 2021 to comply. In order to correct the violation, the respondents must remove inoperable vehicle and remove the overgrowth. Order the respondents to be assessed administrative cost in the amount of $104.39. If the respondent does not comply by January 11th, 2021, a fine of $50 per violation per day should be imposed for each day the violation continues. And the respondents must contact Kenneth Hutchings, Code Enforcement Officer, 321-567-3770 to arrange for an inspection of the property to verify compliance. That's the last slide. Ain't it?
Do you have do you have the documents you want to put in evidence? Thank you. So Exhibit 1 is the affidavit posting and mailing for the notice of violation. Exhibit 2 is the affidavit and posting and mailing of the notice of this hearing. And then Exhibit 3 and then Exhibit 3 will be the cost recovery sheet, the amount of $104.39. And that will be accepted into evidence. All right, a couple of questions. How do we know that's an inoperable pickup truck?
It appears not to have been moved for quite some time. Last week, Wednesday or Thursday of last week, I actually rode by. There's an expired tag on the vehicle.
Okay.
I looked up, I ran the tag. The tag belongs to the vehicle, but the vehicle does not belong to the property owners, and there is a stop order out on the tag.
Okay, so it's got an expired tag on
Yes,
it.
ma'am.
And is the grass and weeds growing up around it as
Yes,
well?
ma'am.
Okay, all right. Is there anyone here? Do we know anyone here on that case? Case 20-46?
According to Mr. Hutchings' notes, he's had no contact with the
No
owner
contact.
whatsoever.
All right, I'll go ahead and find the respondents in violation of sections 13-73 of the city code, inoperable vehicles, and section 6-109, IPMC 302.4, which is weeds. And I will impose a compliance date of January 11, 2021. I'm going to impose a daily fine of $25 per violation per day that will begin on January 12, 2021, if the violations are not corrected, and the respondents are to contact Ken Hutchings once the violations are corrected, and impose costs in the amount of $104.39 are imposed. And then we will have a subsequent compliance hearing to be determined at a future date. Anything else? I think that covers it. Next case. So the next one would be 2049.
20-49. afternoon, Your Honor. I've got 3 items for your review. First one is the affidavit notice of violation that was posted on the property. Second one is the notice of hearing that was posted at City Hall and on the property. And then the third is the cost recovery statement.
Thank you. So that will be exhibits 1, 2, and 3, and the cost recovery is in the amount of $122 even.
Yes, ma'am.
Okay, you may proceed.
All right, so case 2049, our respondent is Lorraine Silvers. The violation address is 2280 Beechwood Court, and the mailing address is the same as the violation address. This hearing is for a public nuisance. The accumulation of the trash and debris on the property and into the right-of-way has continued to increase over the last several months. The items are holding stagnant water, creating nesting and breeding areas for insects and rodents, as well as creating a fire hazard. So the initial inspection for the public nuisance was completed on November 3rd, and a notice of violation was posted. The notice of violation was mailed by certified mail on November 4th and was signed for by the owner on November 16th. The notice of hearing was posted at City Hall and posted on the property on November 17th. Certified mail was mailed on November 11th and signed for by the owner on November 16th. The date given to comply was on November 9th. So on December 1st, I was on site with solid waste to remove trash and debris that had been in the public right-of-way. While on site, Ms. Silvers did exit the property. She's basically said hello and then moved to her car and exited the area. We did not speak about the violation or what she planned to do to correct the violations. I was at the property on November 3rd, the 9th, the 17th, the 24th, December 1st, December 11th, and again this morning. All items still remain on the property, though this morning there was none in the right-of-way. It was all contained on the property itself. So 13-26, conditions constituting a menace to public health, declared to be a public nuisance. The conditions, as described in this section, in a manner and constitutes that may be reasonable or becoming a menace to life, property, public health, public welfare, creating a fire hazard, or providing a nesting or breeding grounds for pests, rodents, etc. So this is from the right-of-way on November 3rd. Like I described earlier, they not only are placing items on the property, but they are being placed into the right-of-way. Again, just different views of the property. So as you're trying to walk up to the front door, the path did become blocked to a point where I could not get to the front door to post on the front door. So
Is there any other access, walking access to the front door?
No, ma'am.
Okay.
So I did post both the notice of hearing and the notice of violation at the public right-of-way on their mailbox. So this is the notice of hearing posted on November 17th. So my follow-up inspection on November 9th.
Is that more?
there is additional items were brought to the property different than what was there on the 3rd. And was piled out in the right-of-way. Oh, that's a double picture. I apologize. So, based on the evidence presented, it is determined that the respondent, Lorraine Silvers, is the owner of the recorded property located at 2280 Beechwood Court, as determined by the property appraiser's records, was in possession and control of the property, was in violation of 13-26. I am requesting that an order be made that the respondents correct the violation on or before the 28th of December. To correct the violation, the respondent must remove trash, junk, and debris stored on the property. Any items that remain on the property need to be stored in a manner that does not allow for the accumulation of stagnant water, does not allow for insects, rodents, or other pests to a place to breed or nest, and does not constitute a fire hazard. I'm asking that the respondents to be assessed an administrative cost in the amount of $122 even. And if the respondent does not comply by the 28th, a fine of $250 per day be imposed.
You go back to the slide that has the definition of the code, the definition of the, yeah, there you go. All right, what's the, it's obvious what the fire hazard is. There's no ability to.
Exactly,
For
the amount of
fire
debris
truck to
that's
get
on
in,
there.
or for EMT personnel to get in, or for people to exit safely, that seems very apparent to me. Just give me a little more about the breeding ground, the nesting ground. I mean, it seems apparent, but just
So
describe
the
a little
items
more.
are out in the open. So they are, and they're being stored close to the property lines, being piled in the right-of-way. So that's allowing weather, rain, any open container, even cardboard is filling with water. And they're putting tarps and things of that nature. So we're creating areas where rodents can feel at ease to congregate, little dens, if you will. And the front yard is the exact same as the backyard. There's the amount of debris that's piled back there. And again, all that debris in a small area, if a fire would start, would just spread to all the surrounding items and surrounding properties.
And then, of course, one of the criteria for setting a fine is consideration of previous violations on the property, and there have been previous violations on this property, correct?
Yes, ma'am.
Okay. Anything else from the city?
No,
And
ma'am.
is the respondent here today?
She is not.
Right, I will go ahead and find respondent in violation of section 13-26, public nuisance, with a compliance date of December 28th, 2020. Respondent shall remove trash and debris, no stagnant water, no fire hazard, remove all of the elements that constitute a public nuisance by the December 28th date. Failure to do so will result in a daily fine of $250 a day, which will be imposed on December 29th if all of the trash and debris, stagnant water, fire hazard, and the conditions constituting breeding grounds for vermin and mosquitoes are not corrected by the December 28th date. The cost of prosecution shall be imposed in the amount of $122, and respondent is ordered to contact May Wright upon compliance with the order, and a subsequent hearing will be held to determine compliance with this order. Anything else from the city? Next case is 20-50.
I have 3 submittals for you. First one is the notice, affidavit for the notice of violation that was posted on the property. The second is the affidavit for the notice of hearing that was posted at City Hall and on the property. And the third is the cost of recovery in the amount of $192.44.
Thank you. That's Exhibit 1, Exhibit 2, and Exhibit 3. 192.44 will be admitted into evidence. Okay?
All right. So case 20-50, our respondent is Aura Grover. The violation address and mailing address are the same. That is 3645 Barna Avenue. This is Unit 23C in Titusville, Florida. There's 2 violation sections, both from the Property Maintenance Code. The first one, subsection 30413, deals with windows, skylights, doors, and door frames. The second subsection is 305.1, that's general interior maintenance. So we received this case from the police department. An inspection of the unit found several windows were broken, and the interior of the unit was found in an unsanitary condition. It was filled with animal feces, soiled clothing, rotting food, flies, and rats. So the initial inspection was completed on August 27th of this year, and a notice of violation was posted at the property. The certified notice of violation was mailed on August 27th and returned vacant, unable to forward on November 6th. The notice of hearing was posted at City Hall and posted on the property on November 17th. Certified mail was sent on November 11th, 2020, and returned vacant, unable to forward on November 30th. The date given to comply was October 11th, 2020. So I've not spoken to the owner of the property, but I did speak with the occupant, Miss Tyra Grover, on December 19th, who identified herself as the granddaughter, and stated she had not been at the property in a while and was unable to clean or repair the windows due to financial hardships.
I'm a little confused. It says that she hasn't been to the property, but you said she's the occupant.
She has stayed in, her items are there at the unit. She's the only one that does stay at the property.
Okay.
But she had not been there. At the point we spoke, she indicated she had not been inside the unit for a while.
Do you feel comfortable that you've got evidence that there is somebody residing at this location?
Yes. When the case was turned over to code enforcement, they were there to respond to a call concerning an animal that was being kept on the premise that had gotten out.
Okay.
And neighbors to that unit indicated that they had seen her at the property and on prior occasions.
Okay, go ahead.
So follow-up inspections were on, September 11th, September 29th, October 15th, November 6th, November 17th, December 11th, and again this morning. So the property is not in compliance. Both windows have not been fixed, and the interior of the unit has not been cleaned. It's still in the same condition.
Have you been inside again?
Yes, ma'am. So subsection 30413 states that every window, skylight, door, and frame shall be kept in sound condition, good repair, and weather tight. Section 305.1, the general interior of the structure. The interior of a structure and equipment therein shall be maintained in good repair, structurally sound, and in a sanitary condition. Occupants shall keep the part of the structure that they occupy or control in a clean and sanitary condition. So this is a picture of the posted notice of violation on August 27th. So this is one of the windows that is damaged on the west side of the unit. At this point, there was cardboard taped on top of the broken window. This is the second window that is broken. It is located on the north side of the structure and to the left of the front door. And while I was there on August 27th, the other window was open. It is functioning though. So this is a picture from that window, just showing the general condition of the room. So on the reinspection on September 11th, it was found that they had attached a bed rail or some sort of framework over the opening of the window, creating a screen, but the glass is not functioning, the window is still not functioning, and it is open to the interior. So while you may not be able to enter, water, vermin, pests can still enter. On the west side of the property, the cardboard had fallen down, which we can see the broken glass. And again, from that window, the interior of the property. So this is the posting of the notice of hearing on November 17th. So recommendations based on the testimony and evidence presented for 20-50, it is determined that the respondent, Ora Grover, is the owner of record located at 2645 Barna Avenue, Unit 23C, was in possession or control of the property, was in violation of subsection 304.13 and 305.1. Order the respondents to correct the violations on or before January 8th to comply. In order to correct the violations, the respondent must repair or replace damaged windows and remove all trash, junk, and debris from the structure and clean the interior to bring it into a sanitary condition. Order the respondents to be assessed administrative costs in the amount of $192.41. If the respondent does not comply on or before January 8th, 2021, and a fine of $50 per violation per day should be imposed for each day the violation continues.
You mentioned that Ora Grover is deceased?
Yes.
Okay. But Ora Grover is still listed on the tax appraiser records and the property appraiser, or the tax collector records and property
Correct.
appraiser records. There's, to your knowledge, there's no probate?
Not to my knowledge. Not that we could find on record.
Okay. And let's see. Are there any children residing here, do you know?
We do have someone to speak today.
Are you aware, are there any children?
Your daughter? I apologize.
Just, I'll let everyone speak and I just want to finish up with the officer. Are you aware of any children or anyone else living there?
Other than the one individual I spoke to, no.
Okay, all right. Anyone who would like to speak, please come on up.
I wasn't sworn in, but I would.
Okay, come on up. Raise your right hand. Do you swear or affirm that the testimony you give is the truth, the whole truth, and nothing but the truth?
I do.
And what is your name?
Irene Garvin,
And where do you live?
2770 Venus Drive, Titusville.
what is your
cousin.
knowledge of what's going on here?
Okay, Earl Grover is my cousin. She passed, April of 2019. She adopted Tyree when she was a baby, up in, New York. Tyree have some issues. She, was trying to get her some help. I was taking care of a lot of her finances when Connorly passed back in April of last year, and my cousin didn't come through on her half to help Tyree out until she can kind of get on her feet and get things situated. And another neighbor came to me about 2 weeks ago and asked that would I get on board again to try to help Tyree get some kind of financial assistance, which I know she should be able to get it. She had a baby before her mother passed, and there was some problems going on, and DCF came in and they removed the child. And she's over in Orlando with our cousin. They finally gave, I guess, full custody to our cousin Crystal. But she do need some help, you know. And like I said, I was helping her, and I've told the young lady that came to the house that I would get on board to try to help Tyree to get probate. Had got in touch with a lawyer in Cocoa for legal aid to get a lot of this stuff situated, because Tyree don't know a lot about what was going on with Connorly after she passed so drastically. We wasn't expecting her to pass that fast, but she did. So Tyree do need help. And to get the place maintained. It is a like a apartment slash condominium. So Connorly are purchasing that unit herself. And the pictures that she showed, I mean, my house don't look like that, but I'm saying I thought it was worse than what she was complaining that it was, but it can be fixed. The windows was, Connorly had a guy to come out to measure the windows to put them in, but she passed. She passed before that was even taken care of. And Tyree don't have no kind of form of income coming in at all. She's now with a friend, staying with a friend. So she having it rough. And she the only one here. Her family live up in New York, her mother, but she have no contact with them at all. So she just here by herself, a young lady.
Well, the windows, obviously, they have to get fixed. And the inside has to get cleaned up. It's not sanitary, especially if there's pets living in there.
No, she have one dog, and it's with her. There's nothing about it at the house.
Okay. Still needs to get cleaned
Yeah.
up. The code officer is recommending that it all has to be done by January 8th, which is almost a month, not quite a month, but 3 weeks to get that taken care of. The window is important because everything's open to the elements.
But it was secured because it was something put up there,
Well, that's not,
but still, a lot of people have broken windows and put stuff, even for AC units, they got boards to their windows. So, but
Well,
I'm just saying, yeah, I understand that it needs to be,
she's a young
but
woman.
financially, she
and
don't have the finance
anybody
to
could
have it fit.
just come in and
Yeah.
break in, and if she's living by herself,
Yeah.
it's a safety issue as well as having moisture coming in. It's could be an issue down the road. It does need to get taken care of, and it does make me wonder whether she's able to take care of this unit on her own, but that's not my business at this point. At this point, I just need to know whether you think she's going to be able to get this cleaned up and get the windows replaced or repaired by January 8th.
I don't see how with no finance help at all. She have been no finance coming in at all. That's why I said she was full, couldn't really pass, was on assistance. But once she turned 18, she had to get it on her own. And her mother couldn't do it for her, and she didn't do it. So I'm quite sure that just the time to go down to Social Security and get her some finance coming in to get her up on her feet.
So what happens in this kind of situation is I make an order, and if it doesn't get fixed by the date the officer has recommended, which to me seems like a reasonable date, January 8th, then the fine will start to run, and it'll run every single day. And what can happen is the city can record a lien, and that lien will attach to this unit so that if someone ever tries to sell that unit, there could be a large lien on the property in the amount for this code violation. That's why you want to get it taken care of as soon as possible. That's why it is a very serious matter to get it taken care of. That's why I'm hoping I could get a positive response that, she can get some help, and a January 8th compliance date would be reasonable. I can extend it to something like January 15th if you thought it was feasible that she could actually do it by January 15th. If not, I don't know why I would even need to change it if you don't think she could come into compliance even by January 15th.
The only problem would be the windows, trying to get the windows in.
Did you want to
The
say
place.
something? No, you're welcome to. If you're living there, you come on up. Come on. Let me have your name.
Tyree Groover.
Tyree.
Tyree.
How do you spell that?
Tibre.
Okay. And you're living there?
No.
You're not living there?
I live there, but I'm at a friend's house. I'm staying at a friend's house. But yes, that is my house. That is my residence. Yeah, so technically, yes, I do live there. But I don't live there since the conditions are like that. But getting it cleaned up, that's no issue. I have a couple of friends that are willing to get a big truck and get some shovels, and so cleaning up won't be an issue. My main issue is getting the windows fixed. That's going to be a big issue of mine. But I already have, a group of friends that are willing to, they have a truck. We get a couple shovels and just scraping the big pile. But the windows are going to be the hardest part. But I can definitely get that apartment clean, like you mean like clean with all the poop and stuff gone, clean before then. But the windows, I might need, I don't know, the best I could do is a wood thing or something.
That I don't know that that's acceptable to the city, but have you gotten any quotes from window
They're
companies?
trying to charge me $1,400 just for that one pane of because my house, this is my side window, it's just one pane missing out, and they're trying to charge me $1,400 just for for the glass. But I have someone, if I act nicely, he'll take me down there and get a glass cut down.
But you have to have someone to put it in too.
Yeah, I have someone put it in, but I'll have the glass. But yes, ma'am.
Okay.
And I'm Aura's daughter, and the reason her name is still on there, I never changed.
You have probate. You have to go
Well,
through probate.
Yeah, I never changed. But
Well,
yeah,
You can't,
You're right, you
really.
have to go through probate, yeah.
yeah. Okay, anything else you want to add? Okay. Anything else from the city at this point? Nothing other than just repairing or replacing the glass from, as far as the city's concerned, there's no other options in terms of the windows.
Not at this time. We can also reach out to her and see if we can come up with some additional options after, but we are still asking for the appropriate relief.
Okay. All right. Thank you.
yes, ma'am.
All right. I find that the respondent, Ora Grover, is in violation of the cited codes, IPMC 304.13 as to windows, IPMC 305.1 unsanitary conditions. The date to come into compliance is January 8th, 2021. The if compliance is not achieved by January 8th, 2021, a fine will be imposed in the amount of $25 per day per violation. Per violation means since there's 2 violations, it would be $50 a day, starting January 9, 2021. I'm going to reserve ruling on the costs. I acknowledge that the costs, and I agree that the costs are $192.44, but I will reserve imposing the costs until we have a compliance hearing. There will be another hearing after January 8th, 2021, where we'll come back and I'll hear this case again to see if you have come into compliance. And then I will reconsider whether to impose the costs. And then we'll talk again about the fines. Okay? Good luck to you. Next case is 20-52.
Okay, this is for property located at 923. 932 is a typo on there. I apologize for that. The first thing I'd like to submit is some exhibits, affidavits for notice of hearing, the cost recovery statement. And notice of hearing. Make sure it's all there. Yep, it's all there.
Okay, so Exhibit 1 will be the affidavit. And notice of violation. Exhibit 2 will be the affidavit and notice of hearing. And Exhibit 3 will be the cost recovery sheet. Costs in the amount of $104.39. Okay.
Okay, again, this is code enforcement hearing case number 20-52. The respondent is Freddie Mae Hampton. The violation address is 932 South DeLeon Avenue in Titusville. Notice was mailed to 975 Nova Terrace in Titusville. Violations is the section 6-109, section 108.1.1 of the International Property Maintenance Code, unsafe structure, section 13-73, inoperable unlicensed vehicles, and section 6-109, section 302.4, the International Property Maintenance Code, weeds. Upon initial inspection, the found structure had caught fire and was damaged to the extent that the City of Titusville Building Department had deemed it uninhabitable. And the other violations that were overgrowth along with an inoperable vehicle. The structure has suffered severe fire damage. Part of the carport has collapsed in. It's pretty much gutted on the inside. The initial inspection was 8/19/2020. Notice of violation posted on site. Notice to respondent was mailed on, certified on August the 20th, 2020, delivered and signed for on August 24th, 2020. Notice of hearing was posted 11/18 at City Hall on property where the violation exists. Certified mail was mailed on November the 11th, 2020, and according to the tracking, the notice is still in transit. The date given to comply was on or before September the 19th of 2020. No contact with the owner. He performed a follow-up inspection on 12/1/2020. The results of the reinspection is it's still in violation. Section 13-73 inoperative vehicles states you can't have one inoperable vehicle on a property for longer than 72 hours. Do you want the whole thing read again, or?
Nope.
Okay. International Property Maintenance Code 6, Section -6109-108.1.1, unsafe structure. When a structure or equipment is found by the code official to be unsafe, or when a structure is found unfit for human occupancy or is found unlawful, such structure shall be condemned pursuant to the provisions of this code. Louise, International Property Maintenance Code 6-109-302.4, anything in excess of 12 inches. Not anything cultivated or flowers, obviously. This is the notice of violation posted by Officer Hutchings on August the 19th. This is the notice of the property is uninhabitable, posted on the property. And I do not remember who posted that. I'm sorry, I thought I had it in my mind, but I've lost it now. Was it Gary? Okay. Gary Stepalofich, who is one of the city building officials, city building inspectors, he actually posted it. As you can see, the property suffered severe damage on the inside. The property was vacant at the time of fire. Like I said, you can pretty much, this is one of the vehicles that's in violation. Back behind at the rear of the vehicle, you can see that big dark spot. That is where the carport is actually collapsed down onto it. This is some of the overgrowth. And this is the notice of hearing posted on November the 18th of 2020. Based on the testimony and evidence presented in hearing case 20-52, it is determined that the respondent, Freddie Mae Hampton, is the owner of record of property located at 932 South De Leon Avenue, located in Titusville, Florida, as determined by the property appraiser's records. In possession or control of the property in violation of Titusville Code of Ordinances, section 13-73, 13-26, and International Property Maintenance Code 6-109-108.1.1 is defined, which is unsafe structure. It is further recommended the magistrate order respondents to correct the violation on or before January 11th, 2021 to comply. In order to correct the violation, the respondents must remove an inoperable vehicle from property frontage, remove the overgrowth, and apply for permits to start either demolition or rehabilitation of the structure. Order the respondents to be assessed administrative costs in the amount of $104.39. If the respondent does not comply by January the 11th, 2021, a fine of $50 per violation per day should be imposed for each day the violation continues. And the respondents need to contact Officer Kenneth Hutchings, 321-567-3770 to arrange for an inspection to verify compliance. Oops, too far.
Have they cooperated at all?
Well, okay. I was out at the property on an unrelated matter one day last week. I met a gentleman who I gave a card to, and I got a call. I'm sorry, I talked to him Thursday. I got a call Friday. It turns out that Ms. Hampton is deceased. I spoke with her daughter, who is in attendance here today. She can enlighten you a little further on that.
Okay. Can you go back to the code, the page with the code provisions on it? Please.
Weeds or the
No,
structure?
the unsafe structure. So, maybe this is for Ms. Farrell. Is the remedy for this to go through the condemnation process, or is it to be fined? Is it a violation to be fined, or is the remedy to go through a condemnation process?
Well, now that we have someone present today, we can work through that with them. I mean, they could rehab it, but that's gonna be something for them to do.
Right.
We were unaware of the people here today.
Well, I mean, I know that some, I don't know if your,
the city-
if
the
your
ci-
codes follow like an administrative demolition process where you know, give somebody notice and then they have so many days to contest a
Correct.
finding of an unsafe structure. And-
Right, we have a process for
But
that.
this is not what you're not following that process.
It could be set off from this hearing, but that's a separate process that goes through city council.
Okay, right.
Once we have this hearing that it is in that state of condition and they do not bring it into compliance and/or start a process to that, then we would take it to that next level.
Okay. Okay.
And for further clarification, the city's code section 6-109 incorporates the International Property Maintenance Code and allows the city to utilize any of those sections as a fine, to make a finding a violation. And the city has previously and regularly used this particular section on 108.1 to make findings of code enforcement violations regarding this set of facts.
Yeah, it's just that it says shall be condemned. That's why I'm bringing that question up.
I think that relates back to the notice that was posted by the building official as far as it has happened, and because of the status that this property is in, the building department has found that this property shall be condemned and turned it over to the code enforcement department for a finding of violation.
Okay. All right, ma'am, would you like to come up? Did you already get sworn in?
Yes, I got sworn.
Okay, can you tell me your name and give me your address, please?
My name is Catherine Jefferson. I live at 975 Nova Terrace.
Then in Titusville?
Yes, in Titusville, Florida, 32796.
And what is your knowledge about this property?
Okay, Freddie Hampton was my mom. We was in the, after I was in the process of putting the house in probate because my mom was deceased. I got sick, and for a while I didn't have no income coming in because I wasn't working. So then I had to put the probate thing on hold. And then, you have to just bear with me a little bit. And then, someone murdered my son. He got murdered. So that just like took me completely out of, I just went, I lost it for a while. But I'm seeing a psychiatrist and a psychologist. I know I'm not trying to put no sob story on you, but I'm just telling you what I've been going through for since my mom passed and since my son was murdered a week this month on the 18th. So after they murdered my son, somebody went and set the house on fire. I was not able to handle anything, so I so I just told my brother, you know, I said, look, you're gonna have to handle it because I'm in no position to handle anything. I couldn't even take care of myself for a while. But I'm on the road to recovery. So my brother tried to get a loan to, you know, but they don't have no funding right now. So he couldn't get, no funding to redo the house. So we were rebuilding, because we were working on the house when somebody destroyed the house. So then I had a friend to come, and put a trailer on the house to keep people from going over there, stealing the house, stealing stuff from the house, breaking into the house, into the property, and doing all that. So just, long story short, I'm supposed to be the strong one out of me and my brothers. I'm the only girl. But I'm on the process now of getting myself back together, and I'm putting the house, back in I'm gonna put the house in probate. So me and my brother both can be over the house and get repairs, because the stuff that we bought out our own money when I was working, somebody stole everything out of there. And I've been talking to contractors, trying to get somebody to tell me how much it'll cost to, first thing, talking to my friend, because he does that construction work, he said, the first thing we need to do is redo the roof. So that's what, I'm in the process now of, doing fundraisers and like I said, it's just been a long road back for me.
When was the fire?
Huh?
When was the fire?
I think it was in January. I think it was in January. I think because I think it was in January. I can't really remember when all this happened with my mom, then my son, and I'm on, like I said, I've been, talking to a psychiatrist and psychologist, so I'm on the road to get myself back together and stuff. Mm-hmm. And then I'll be able to fix up the house like it was, but the house, it was arson. We just don't know who did it or why.
And there was no insurance on the house?
No.
No.
Because like I said, I was in the process of putting the house in probate. I had already done talked to the lady. She had already did all the paperwork, but getting sick at work, and I'm still not back to work yet. You have to excuse me, that's the way I breathe. But anyway, I had to stop everything, But I'm getting myself back together, and I'll be able to rebuild our family home. Because we the ones who built that house. Me, my brother, my uncle, my mom, my dad, and this other man. We the ones who built this house. So like I said, I want to rebuild it again. I want the chance to rebuild it.
Mm-hmm. Wow, you certainly have gone through a lot. So it has been found to be an unsafe structure by the city, yeah. Which at this point, the city has made a determination that it can't be lived in, and it's either going to have to go through a process of getting demolished, or some very serious repairs would need to be done if it's structurally sound.
The guy who I talked to said first we need to start with with the roof. I guess redo the roof first. That's what he told me, and then work on. I guess you have to gut everything out. What they say gut, I don't know what it means. But they say gut the house. I guess just take everything out and just start. But just leave the outside structure and just start from the roof and then rebuild everything. That's what I was told.
So that, again, how this process works, the code enforcement process would work, and I don't know about any separate administrative process the city might follow. The city might follow a demolition process, but for the code enforcement process, what we do here is we find whether there's a violation and the property is in violation, you get a certain amount of time to bring it into compliance.
Yeah.
I don't know if you could bring this property into compliance short of demolishing it at this point. If you don't have the funds to repair it, and if you don't bring it into compliance within the time frame well, the city is recommending a January 11th time frame, but even if I extended it, it doesn't sound to me like you have any kind of funding available to make the kind of major repairs that might be necessary to make this structurally sound.
To contact legal aid and see what they can do, see what kind of help they could do. And I'm gonna contact, you know, the other, I can't think of the people who deal with, you know, when you have tragedies. I'm gonna see what they can do for me too. You know, see if I can get some kind of funding from them.
Right.
Yeah.
Well, there are two violations that we have today that would be fairly simple to
Yeah, I
correct.
know.
But like the weeds,
Yeah.
that, they just need to be cut. And
Yeah.
that's a pretty easy one, right?
Yeah,
That
yeah,
could be done.
the guy who supposed to been taking care of the yard, came by, you know, he did some of the work, but he didn't do it all. So, you know, that, and I don't know, like I said, I know one of the cars belonged to my brother, and I told him to move it. He was waiting to get the, whatever he had to get, to a tag or something to put on the car so he could move it. So I told him he had to move the car, and I don't know who the other car belonged to, so we've been trying to find out who car it is, you know, because I don't really know who put their car there. Yeah.
Well,
So I guess we'll just have to have that one towed.
that one just needs to get removed or tagged.
Yeah, that one just has to be towed. I don't know who it belonged to, you know.
So those two are pretty simple and can be done, that can be fixed very quickly. The unsafe structure is a much more complicated issue.
But I'm ready to get started on the house. It just
Okay.
took me you know, it just took, I'm not 100% back where I was, but it just took me a while to get to, I just thank God I'm back to this point where I can function.
When did you know that the city had issued this notice of violation?
I got a call, like he said you know, because I got somebody there, you know, at the house because people been threatening to, you know, do more damage to the house. I guess whoever started the fire been, you know, I just been getting, I don't know, rumors or whatever. So he said that he talked to the guy, and the guy was telling him about the meeting today. So he, you know, so he gave me the guy number, and that's when I called the code enforcement, Mr. Frank, I think that's his name, right? Yeah, Mr.
Yes,
Frank, and I talked with him on the phone.
I would suggest that you also meet with Mr. Lewis and Mr. Tolleson and talk about the city's, any options about the structural soundness of the building and the demolition process, and there's that process.
Yeah.
But I'm gonna go ahead and make a ruling on the violations that have been presented to me today.
Okay.
Is there anything else you wanted to say?
Yeah, like I said, I want to rebuild the house, because that's been in our family for years, you know,
I understand.
and I want to rebuild.
I understand. Anything else from the city?
No, ma'am.
Okay. All right, I do find that the property is in violation of section 6-109, IPMC 108.1.1, unsafe structure, section 13-73, inoperable vehicle, section 13-26, weeds.
Yeah.
and find that the property shall come into compliance by January 30th, 2021. Fine shall be imposed in the amount of $25 per day per violation, so that's 3 violations at $25 per day
Okay,
per violation.
okay.
Contact Ken Hutchings when you are in compliance, but we will have another meeting to determine if you have come into compliance.
Okay. Yeah.
I'm
Me and
going
my
to
brother.
reserve ruling on costs for now, and we'll
Okay.
reconsider the costs of $104.39 at the next meeting.
Okay.
Thank you. Next case is 20-53.
I broke it again.
Can we get the next PowerPoint?
Ah, there it is.
Go ahead.
Okay. This is code enforcement hearing case number 20-53. The first thing I'd like to do is submit the affidavit of notice of violation, the affidavit of notice of hearing, and the cost recovery statement.
Affidavit and notice of violation will be Exhibit 1. Affidavit and notice of hearing will be Exhibit 2. And Exhibit 3 will be the cost recovery statement, which is in the amount of $104.39. Okay, go ahead.
All righty. This is reference to property located at 1427 Prospect Street here in Titusville, Florida. The respondent is Philip A. Watson. The violation address is 1457 Prospect Street. Everything was mailed to 1427 Prospect Street. The violation charges were Section 13-73, inoperative vehicles prohibited, and Section 20-58, vehicles stored in yard. The narrative of the violation, upon initial inspection, found numerous vehicles without tags and inoperable parked throughout property frontage. Okay, the case summary, the initial inspection with Officer Hutchings was done on August the 26th, 2020. Notice of violation posted on site. The notice to respondent was mailed August the 27th, delivered September the 8th, 2020. Though not signed for, it was COVID on receipt. But the notice of hearing, November the 18th, 2020, posted at City Hall and on the property where the violation was existing. Certified mail was mailed November the 11th, 2020. According to the track, and the notice is still in transit. Date given to comply was on or before September the 9th of 2020. According to Officer Hutchings, he had no contact with the owner, but on November 24th, an individual whom is helping property owner called, to which was informed as what needed to be done in order to bring the property into compliance. He performed follow-up inspections on October the 1st, November the 10th, and November the 18th. The results of re-inspections for Officer Hutchings was the owner had not removed or registered vehicles. City code defined, can't have inoperative vehicles longer than 72 hours on the property. And section 20-58, item A, miscellaneous parking regulation. There shall be no off-street parking in the front, side, the rear yards, the street side of single-family dwellings except as normally exist in driveways or designated parking spaces or areas unless otherwise provided in the section. This is actually the notice of violation part, posted on one of the vehicles that was in violation, August the 26th. There's one of the vehicles in violation, two of them actually. There's others. The gray vehicle in the front there had the left front wheel up on some type of device or block or object ramp of some description. Vehicle no tag. There's a notice of hearing posted by Officer Hutchings on November the 18th. You can see where the one vehicle right there is actually blocking the sidewalk, parked across the sidewalk. The recommendation is based on the testimony and evidence presented in 20-53 Titusville Code Enforcement Board determined that the respondent, Philip A. Watson, is the owner of record of property located at 1427 Prospect Street, located in Titusville as determined by the property appraiser's records, in possession or control of the property and in violation of Titusville Code of Ordinances, section 13-73 and 20-58 as defined. It is further recommended the magistrate order the respondent to correct the violation on or before January 11th, 2021 to comply. In order to correct the violation, the respondent must remove inoperable untagged vehicles from property frontage. Order the respondents to be assessed administrative costs in the amount of $104.39. If the respondent does not comply by January 11th, 2021, a fine of $50 per violation per day should be imposed for each day the violation continues, and the respondent must contact Officer Kenneth Hutchings at 321-567-3770 to arrange for an inspection of the property to verify compliance. That being said, I was by the property today at approximately 12 p.m. and there were 3 vehicles gone. The property owner is here in attendance.
So it looks like some attempt at compliance?
Yes, ma'am. The gray vehicle is gone. The vehicle there with the wheel up on the ramp or whatever is gone. The brown vehicle back behind it, this Dodge, is gone. There's another vehicle out to the side that he missed a picture on. That vehicle is still there. And there's another vehicle, there's still at least 3 vehicles there where were there at 12 o'clock that were in violation.
So, is there any yard parking still?
Yes.
Still yard parking?
Yes.
So the vehicles that are left,
Yes, ma'am.
They're
It
still
appears to me that this white Lincoln right here on the right side of the picture has been moved out of that slot, and there's a 4-door brownish gold Oldsmobile parked there, and that vehicle is out blocking the sidewalk.
so there's still yard parking and there's still some vehicles that are inoperable?
Yes, ma'am, that is
as of-
correct.
As of today?
That was at 12 o'clock.
Okay. And any other past violations on this property that you know of?
Not that I can vouch for, no, ma'am.
Okay, thank you. And is there someone to talk about this case? Come on up. Did you get sworn in today? I'll go ahead and get you sworn in. You raise your right hand, please. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
And please state your name and your current address.
Philip Watson, 1947 Prospect Street, Titusville, Florida. 1427 is what. Yeah, since he looked, the guy finally beat the bushes and got somebody to take them. It's hard getting rid of them. He picked up 2 or 3 more. So the only ones left is that old rusty one. I put the cover over it, and he's coming back, I don't know, later today or tomorrow. Then that'll be all illegal vehicles gone. And I cleaned up around the back of the house some to put it out the road and call the waste disposal. So,
You don't have any pictures.
no, I didn't. I don't really know how to use a smartphone, but it don't have a date. I figured y'all needed a date, or else it could have been an old picture, but nah, go look at it again and see.
Okay. So you're saying that the only one left is this, the brown one, and is that in the driveway, or where's that
Yeah,
one?
the rusty one they showed there, that old Lincoln, it's in the drive. I put a gray new cover over it, and the tow truck guy's coming in tonight or in the morning to get that one. So that'd be the last of them gone.
Are there any cars in the yard right now?
No, ma'am. And I know there's a blue one at the side of the house. That's not mine, that's the neighbor's. So that's not my deal.
It's not your property?
No, I don't know what that address is next door there. It's to the south side of me.
Okay. Okay, well, because you still have one, so the officer is asking that you have until the 11th of January, which should be plenty of time to get rid of the one. So assuming you can get rid of that one by January 11th, there should be no fine imposed then.
Okay.
And we appreciate that you hustled and
Yeah,
got all
it's-
those done.
You know, when you go to buy cars, they're gold. When you go to sell them, they're trash.
Absolutely.
So,
Okay, I'll go ahead and go ahead and do a ruling, and you'll get that order in the mail. I'm going to go ahead and find that the property was in violation of 13-73. Based on the testimony of the owner, I'm going to find that he brought the violation of 20-58, parking in the yard, in compliance as of today. So the violation currently existing is 13-73, inoperable vehicle. Compliance date will be January 11th of 2021. If all inoperable vehicles are not brought into compliance by January 11th, 2021, meaning don't bring any more back, a fine shall be imposed in the amount of $50 per day that will begin to run January 12th, 2021. And I will reserve ruling on costs until we have a compliance hearing. If we'll have a compliance hearing in January, and assuming everything is in compliance, then I'll consider whether or not to impose the city's request for costs.
okay,
Okay?
all right.
Thank you.
Thank you. I can go now.
Yes, you can. That's it. And is there a code enforcement manager's report today?
Not today, ma'am.
Not today?
Nope.
Well, then we have successfully completed our first special magistrate hearing. Very well done, everyone. Thank you. We are adjourned.